We return to the cold truth that abortion is murder. Now for our fourth point. For those living in the United States and other countries with similar governing principles, abortion cannot be accepted under any vestige of the law. It is fundamentally rejected by every major law and legal document. This is not our interpretation, it is the only interpretation. Laws are written to be clear, and any failure to accept their wording means people have the right to peacefully protest, but it does not give license to do whatever they want just because they disagree with it, which is what women have done for 3,500 years at least, namely, get illegal abortions that subject them to legal repercussions. Let us look at some of the defining legislature of the United States of America, as signed by the executive and accepted by the judiciary, as legal, binding, and, until such a time as the liberal conspiracy flushes any attempt to save the lives of millions down the proverbial toilet, has power to prevent any and all abortions that do not fall into the three exceptions. Though it technically has no legal authority, the exceptionally important Declaration of Independence has guided the creation of many of the laws of the United States and the Constitution that comes from it. Here are a few excerpts from that transcendent document that lay down with absolute clarity the Founding Fathers' unanimous opposition, or what would be their unanimous opposition were they alive today, of abortion. We hold these truths to be self-evident that all men are created equal. The Founding Fathers were mostly Christian deists who believed in the creation of the world by a divine and omniscient being. Whether you believe that or not, it is one of the most core principles that governs the United States, that men were created, not born out of thin air. All men are created equal means that, at the moment that their physical body came into being, they had no advantages or disadvantages, and any advantages or disadvantages that they would come to see would come as a result of their genetics, their social class, and what they would eventually do with the gift of life. It was clear that the Founding Fathers believed, therefore, since they knew no doubt of many offspring who would perish before ever leaving the womb, that it was at the moment of conception that all men are created, at least in the flesh. All men are created by a combination of male and female genes, and, if you believe in him, God. That is the core principle of the Declaration of Independence. Since they believed that all men were created equal, no matter what changes they underwent to take away their equality, they believed that all men, which means people, should have the chance to be born, if any do. The idea that a human being would be intentionally denied birth was no different than the idea that a human being would be forced to pay taxes for services they themselves would never receive. That they are endowed by their Creator with certain unalienable rights. Again, these truths are self-evident. Or, in other words, they should be obvious. All men have been given unalienable rights, meaning rights that cannot be taken by others and that can never be changed. What are rights, then? Women have been marching on Washington lately with signs that say such mantras as, "It's my body, it's my right." But is it? By that standard, any man could have the right to rape any woman he wants. After all, it's his body, it's his right. People could be allowed to walk around nude in public. After all, it's their body, it's their right. Don't believe us? Let's dive into what a right really is. Let's look to the dictionary again, since that is a resource most people trust. A moral or legal entitlement to have or obtain something, or to act in a certain way. No sense of morality will justify the murder of innocents. So what then is a legal entitlement? Well, legal of course means given by the law. That means it is the law's responsibility to determine what people are entitled to. Entitlement means the fact of having a right to something. So here we get some circular definitions, but we can work with this. First, it must be a fact. It cannot be something mythological. Facts prove that abortion is murder. Myths claim that it is not. Facts prove that embryos and fetuses are alive. Myths claim that they are not. So, what are the factual rights? They can only be those rights which are absolute and proven. To have a single discrepancy means it is not a fact, it is a mere fact, which is as good as a myth. Therefore, every person must be entirely and without question entitled to the same right. A person cannot possess a right that another does not have, and a person cannot be denied a right given to another. There is enough to say about this to fill every inch in all the libraries in the world and not cover a percentage of it, but the Founding Fathers mentioned 3. That among these are life, liberty, and the pursuit of happiness. Each of these is rejected by pro-choice. First, life. Every human has the right to live. This is unalienable. It is self-evident. Since an embryo is alive and a fetus is alive, and that embryo or fetus is the offspring of a human, it is entitled to live. This is the foundation of our nation. Second, liberty. Liberty does not mean freedom to do what one wants, though if it did, that would mean abortion denies that inalienable right to fetuses too, since they will never do what they want. Liberty specifically means to be free to act, no qualifiers. We have already established that one cannot simply act however he or she wishes. Rather, they can, but they cannot do so without consequence. Therefore, liberty is just freedom to act. The aborted will never have that freedom. Finally, the pursuit of happiness. Again, they never said happiness was a right, only the pursuit of it. An aborted fetus will never have either in this life. 3 inalienable rights, self-evidently established. Pro-choice wishes to eliminate them and convince others that they are not obvious. Other passages are less clear, but if we wanted, we could theoretically dissect the entire Declaration for anti-abortion. Instead of spending our time proving what we strongly believe every citizen of the United States already knows, we will move into documentation that has actual power. The Constitution of the United States of America, on which at least 160 other constitutions are at least partially based. Specifically, the preamble and the amendments define clear and definite rights for all Americans, and that includes American fetuses. From the preamble, which defines the purpose of the Constitution and all dependent laws, we the people establish justice. We have already mentioned justice, but we will do so again. Justice is cold, unfeeling, and unforgiving. It is often depicted as the opposite of mercy. Mercy can only be given at the expense of and with the willingness of the giver. There are many in the United States who scream out for mercy, mercy from the consequences of their actions, but who can pay the cost of mercy? Who is willing to use their own time, money, and resources to give the kind of mercy that is asked for, namely, to prevent unwanted pregnancies so women can have wanton sex? There is a mercy that a child can be carried, delivered, and given up for adoption. There are merciful people who are happy to adopt that precious life and raise it as their own. However, they cannot do that if that life is ended prematurely. Meanwhile, the demands of justice that cry out against those who have had an abortion remain unmet. The demands that everyone have a chance to live. The demands that those who take a life pay with their own. That is justice. It is harsh and unrelenting. The American Constitution, by its own preamble, is defined to establish justice. It is not to establish mercy. We the people ensure domestic tranquility, provide for the common defense. These 2 points are best served together because they are equal and opposite. Providing for the common defense means protecting the nation from foes without. As the foil for that, ensuring domestic tranquility means protecting the nation from foes within. The plague of abortion ends 1 million American lives every year. We have deployed troops for far less. To ensure domestic tranquility means to protect the common citizens from murderers who would steal their lives. The whole purpose of the Constitution, as is stated, is to protect those lives. As for providing for the common defense, this plague of abortion is not native to the United States. Despite the more liberal parts of Europe being 30 to 40 years behind the United States in social and economic development, the American people are conditioned to see Europe as the ideal for the future. Providing for the common defense means not allowing the influence of Europe and other places who claim to see the future but are truthfully behind to push forward the ideals of America. A cursory look at the regression of human society and quality of life in nations seen as advanced shows that they are not worthy of emulation. The Constitution does not give ground to Europe or any other geopolitical division to control or influence us protecting our people. That includes our innocent, unnamed people. We, the people, promote the general welfare. General means not everyone can be spared every discomfort, but that the majority of people can be protected from the greatest discomforts. The welfare of women may be at stake if they give birth, but the welfare of children is certainly contingent on their ability to be born. The Constitution requires that the path that leads to greater well-being be taken. Barring cases where one life must be spent so another can be spared, the general welfare requires that children be born even if it causes some discomfort to the women who chose to create them. Again, if they did not choose, that could be argued as one thing, but if they did, the Constitution protects their offspring's general welfare over their specific welfare. We, the people, secure the blessings of liberty to ourselves and our posterity. Again, the women who chose to have unprotected sex have had their liberty. They now have posterity. The Constitution protects that same liberty for their posterity. Now for amendments. Amendment 1. Congress shall make no law abridging the freedom of speech. What greater abridgment of freedom of speech can there be than to literally remove the ability of a person to speak ever? That means that Congress shall make no law to end lives that did not have freedom to say or do what they wanted. A murderer who kills for gain or pleasure has had their freedom to speak, at least with their actions, and killing or imprisoning them is justice. An infant has never spoken nor acted, and therefore killing them is a direct abridgment of their fundamental freedom. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state. This is a bit esoteric with relation to children, but allow us to make it abundantly clear that this right applies to all unborn children just as much as to any criminal. When an American citizen is accused of doing something punishable and is brought to trial, they cannot be tried behind the scenes, nor can the individuals who accuse them be the ones to make the decision about their fate. They must be tried openly with no secrets, and they must be tried by people who have no other desire than to uphold the law. When a fetus, which is an American citizen, is blamed for the discomfort or loss of something other than the life of a mother, that fetus, as an American citizen, has the right to have the grievances of the mother made public and to be tried by an impartial jury. In other words, neither the mother nor the father can be the one to make the decision of whether the child deserves to die. That is the fetus's right according to the Sixth Amendment. The Seventh Amendment confirms this right and confirms that no higher court can overturn whatever decision is made if the child is found innocent. Amendment 8, slightly paraphrased for context. Cruel and unusual punishments shall not be inflicted. Though there is a lot of question as to what the individual minutiae of cruel and unusual punishment is, the accepted overarching definition, as recited in Wikipedia, is as follows. Cruel and unusual punishment is a phrase in common law describing punishment that is considered unacceptable due to the suffering, pain or humiliation it inflicts on the person subjected to the sanction. In other words, suffering, pain, and humiliation are the components of this amendment, which has been reflected in many other constitutions. While a fetus may not be able to process humiliation, they can certainly feel pain. As we will mention later, the process of abortion causes pain to the fetus that is so great they typically expire long before the process is complete. As abject and objective torture, akin to either a slow and painful death by poison or a quick and painful death by drawing and quartering, American citizens and citizens of many other nations are protected against being aborted, as it is cruel and unusual punishment. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Just because the Constitution does not speak specifically of fetuses who are American citizens, does not mean they are not worthy to receive and retain all rights to which any other citizen may be due, whether those rights are specified or not. Though no other amendments can be used as effectively to crush this conspiracy, one amendment should be more than enough. Next time, we will get into the truly juicy stuff, judicial precedent. The cold truth honors the law.